All rise. The Court of Appeals, Division 1 is now in session.
Good morning. Please be seated. This is the time set for oral argument in Neff against Risen. Our cause number 1CA CV21-0236. Counsel, you'll each have 20 minutes for oral argument, and the appellant is responsible for watching your own clock on rebuttal. As you can see, we have socially distanced the courtroom. I ask you each to argue from the podiums at your counsel table rather than the central podium, and that, I think, gives you adequate discretion as to whether to argue masked or not. And with that, we can begin.
Thank you, Your Honors. Good morning. Jesse Showalter and Joel Robbins of Robbins & Curtin on behalf of Plaintiff Appellant Dakota Neff. We're here asking that the trial court's ruling be reversed. The trial court erred when it determined that Dakota Neff's notice of claim failed to set forth a sum certain. That ruling's an error because what the trial court held is that any statutory beneficiary who makes a notice of claim against a government entity for wrongful death must make a global offer to settle on behalf of all other statutory beneficiaries. And if they fail to do so, they haven't set forth a sum certain. The reason that's an error, Judge Swan, you look like you're... Oh. The reason that's an error is that Arizona law and this court's opinions and the wrongful death statute itself recognize that each wrongful death beneficiary has their own legal claim. And when a wrongful death action is ultimately filed, it's a single action with a single with a single plaintiff. Each beneficiary has their own legal entitlement to damages. And this court found that in Quinones and Nunez. What the trial court did is it effectively determined that unless a wrongful death beneficiary is able to make a sum certain notice of claim on behalf of all wrongful death beneficiaries, which is a universe that at the notice of claim stage may not even be knowable, that unless they can do that, they can't bring a wrongful death claim against a government entity because they will never be able to assert a sum certain.
What's your position now with regard to the other statutory beneficiaries?
We've never been authorized to act on their behalf. Dakota's never been authorized to act on their behalf, and we have no reason to believe that they've ever done a notice of claim.
So you're asserting no position with respect to any other statutory beneficiary on appeal? Is that right?
That's correct.
I just wanted to clarify. Yeah.
So just to make sure I'm clear, so what you're saying is that for the unrepresented statutory beneficiaries that are not here today, you think we should affirm the dismissal as it relates to those individuals?
The only reason I'm hesitant to say yes is that I'm not sure that the others...
You think I'm laying a trap, but I'm not. I just want to make sure that...
The other reason I'm hesitant is I'm not sure that La Paz County or Sheriff Reeson ever set forth a sufficient evidentiary basis to say that no notice of claim was received. But we have no reason to believe they ever submitted a notice of claim, and so I don't think there's any other real choice but for this court to...
There's no notice of claim filed, and the trial court dismissed it on a lack of notice of claim as it relates to the other. So there's no basis upon which we could say, or we could do anything else but affirm that ruling. You would agree
I think
with
that's
that?
correct, Your Honor.
Okay, thank you.
Yeah, I think where the trial court went wrong is a terminological distinction. Arizona's wrongful death statute distinguishes between statutory plaintiffs and statutory beneficiaries. A statutory plaintiff by definition, under the plain language of a statute, has to be somebody who has initiated a lawsuit. And Wilmot is consistent with that. Wilmot is a case that involves a statutory plaintiff, and it has a discussion of whether a lawsuit can be settled before it's been filed. And it makes clear that at that stage, the person who could settle a lawsuit is not a statutory plaintiff, but it would be somebody termed a statutory trustee. In this case, Dakota Neff was never a statutory trustee. She was never authorized to do anything, and that seems to be the source of the trial court's error, is to say that back when Dakota Neff filed her notice of claim, she was somehow a statutory plaintiff, which is a legal impossibility based on the clear expression of the legislature's intent in the statute. One of the arguments that appellees raise is this claim that we invited the error. That's simply not accurate. The case law that they cite for that is generally the one that stood out to me was Atchison, where a man converted a Porsche, and then at trial he said, well, I was having a big alcohol problem, and so I was going into rehab and stuff, and he introduced that evidence, and then on appeal said that was error. That's an invited error, is when somebody introduces evidence and then later on seeks to appeal from that introduction of evidence. That didn't happen here. What happened is, at the trial court level, once the suit had been filed, Dakota Neff had she had a fiduciary duty to the other beneficiaries. And to that end, when faced with a motion to dismiss, she made an argument for mercy. She said, trial court, don't dismiss. The trial court did not accept or adopt that argument, and that is not the basis for the trial court's ruling. We didn't invite the error. The trial court adopted a position that appellees set forth, not in their motion, but in their reply, and we think it's clearly error. On its face, Dakota's notice of claim complies with the statute, and as to the final argument that I think appellees raise, which is this assertion that Dakota failed to set forth sufficient facts to allow La Paz County and Sheriff Reeson to understand the basis of liability being asserted against them, it's really clear from the briefing at the trial court level that their problem is not with the facts, it's with the legal theories asserted in the complaint, or in the notice of claim, that they feel that we should have used the phrase direct liability. And case law is really clear that at the notice of claim stage, parties are not required to put all the theories of liability they intend to assert. If there are no further questions from the court, I'm going to reserve the remainder of my time.
Thank you.
Good morning, Your Honors. My name is Justin Ackerman, and I represent Defendant Appellees Sheriff William Reisen in La Paz County. One very tangential thing I'd like to point out before I get into the argument is that the court affirmed the dismissal of La Paz County in this case. It's really just Sheriff Reisen, and so to the extent the arguments touch on him, I'll just be referring to him. The court should affirm the dismissal of all the claims in this case. As appellant had just conceded, the statutory beneficiary claims should remain dismissed no matter what decision this court reaches because they never filed a notice of claim to begin with.
Well, I mean, we're talking now about claims, putative claims by people who are not parties to this action or this appeal, right?
At this point, they've never made an appearance. They've never filed a notice of claim. They have no basis for any damages in this case.
So it doesn't sound like there's much disagreement about that point.
Not at all.
All right.
With regard to Dakota Neff, this record on appeal really turns on the arguments raised below. When we filed our initial motion for judgment on the pleadings.
Well, on that, Mr. Ackerman, we review the ruling on a 12b6 de novo, correct?
That's correct, Your Honor.
Okay, so let's start there. Ms. Neff filed a notice of claim, and the notice of claim was timely,
Yes?
and you file a motion to dismiss the notice of claim. And was it geared to Ms. Neff, or was it geared to the...
It was not geared to Ms. Neff. It was geared to the statutory beneficiaries who did not file a notice of claim.
Okay, and if we only had Ms. Neff in this lawsuit, you would not have filed a notice of a claim argument, correct?
If plaintiffs had not responded to our motion for judgment on the pleadings with the argument that Ms. Neff filed the notice of claim in her capacity as a statutory plaintiff, our reply would never have argued the entire notice of claim was deficient for a sum certain. But that's precisely what occurred.
But we're reviewing this de novo, so we can say, okay, the other statutory beneficiaries are out, and you have just conceded that the notice of claim was timely filed by Ms. Neff.
It was timely filed by Ms. Neff. That's correct.
Okay. So let's move to the other part of your argument, which is the facts in the notice of claim. What's your best case to say that in that early stage you have to put in all of those facts that you're probably going to find out through discovery, right?
Well, Your Honor, the Deer Valley case states, and it's the language of the notice of claim statute, that all claims shall contain facts sufficient to permit the public entity to understand the basis upon which liability is claimed. And so there's a stark contrast between facts regarding wrongful death and facts that would support a future claim for negligent supervision, negligent training. I mean, the discovery that would be conducted regarding those two different claims would be entirely different.
But you don't need to care about that, because the purpose of the notice of claim statute is to inform you of the basis of the claim and enable the public entity to make an intelligent decision as to whether to settle for the sum certain that Deer Valley actually talked about. Are you saying that the real hiccup here is that the county was, or the public entity was simply confused?
No, the hiccup here is, contrary to their arguments, it's not that the notice of claim needs to say, I'm bringing a claim for wrongful death involving a battery and assault, I'm bringing a negligence claim, I'm bringing a negligent supervision claim. Those terms don't need to be used in notice of claim. But it does need to state facts that would apprise the municipality of what future claims could be brought, because how else do they evaluate potential exposure and liability without knowing what facts are at issue? Again, if there is a wrongful death claim, which clearly has been asserted in this notice of claim, and then there's also a negligent supervision claim, that's additional liability, it's additional damages that the county would be able to assess.
Well, what would the additional damages be? The damage here is the alleged wrongful death, right? Mm-hmm. Negligent supervision may have contributed to that. But if we take it out of, let's just take it out of the notice of claim world into a straight tort case. You've got a wrongful death arising out of a motor vehicle case, and then there's negligence, entrustment, gross negligence, all sorts of theories thrown in there. Mm-hmm. The damages are the death, right?
Well, to the extent that there are damages computed for the death, there could be punitive damages that are separate and direct.
Were there any punitive damages asserted here?
Your Honor, I can't say 100%, but I believe the complaint had asserted, if it didn't directly assert punitive damages, it certainly said any damages that the court could award, which could include punitive damages.
Okay. Does that render the notice of claim defective? Because I didn't see anything in Deer Valley that would say that renders the notice of claim defective.
I would be honest, Your Honor, there's not a case on this yet. This is an issue that we continue to face from the defense counsel perspective, that we get these notices of claim. And they usually typically assert the facts that are asserted here about the incident arising, but they have absolutely no facts about any kind of future negligent supervision, negligent training type claim, and then these claims are then filed. And how is the county supposed to evaluate its potential liability and exposure?
I think the county is well aware of the fact that the person died.
Sure.
And they're well aware of why he was in their control or custody. What more do you need to know to assess all of the facts you're talking about are within your control.
Well, damages are one aspect. They're one aspect of the evaluation that would go into whether or not the county would want to settle on a notice of claim. They're also evaluating, what is this case going to cost us to litigate?
It sounds like you want us to, as a matter of judicial fiat, create a regime sort of like 122602 through 122604 for these cases, and just require some fulsome disclosure. The next step, you'll ask for preliminary expert affidavits. It doesn't seem to me credible to say that the county is, or any public entity based on a notice of claim like this, is in such a poor position to evaluate settlement that it couldn't make a decision as to whether to settle for the sum certain or not. It sounds more like there was no way the public entity was ever going to settle for the sum certain here.
Well, are we talking in the abstract, or are we talking about the specific facts in this case? The sort of trifecta factors of what the county is looking at when evaluating the notice of claim, it's permitting a public entity to investigate and assess liability.
Right.
If you don't know that your policies are being challenged or could be challenged in a future lawsuit, how do you investigate to see whether that's a valid issue or not?
It seems that you're in control of all the facts.
We are, but we don't know what to look for if we don't know what's going to be challenged.
Well, going back to Judge McMurdy's question, you know that an individual in the custody and control of the public entity died, and you know that the allegation is that the manner in which his custody was handled caused that death. That's not enough for you to start looking for facts?
Well, sure, you're looking for facts, but okay, so every time a death occurs in a jail, is the court imposing an obligation upon a municipality or a jail to investigate every single one of its policies that could potentially be at issue, to look at every single officer involved and see if there's any sort of supervision issue?
Yes, because you control the policy, you made them. You control the facts and whether there's a policy, whether you have abided by those policies. The plaintiff at that early stage doesn't have access to any of that. You do.
That's not entirely true. A plaintiff can make a public records request to get any of that information.
And then you would be the one to produce those records. I suppose I would throw the question back at you. And are you saying that people can simply die in your custody and you're under no responsibility to contemplate why?
That's not true at all. But if we're trying to evaluate what facts have put a municipality on notice as to what they need to investigate, certainly a one-line sentence in a notice of claim saying, oh, and by the way, your staff were not properly supervised and trained. That's all that would have been required here, and I would not be making this argument.
You couldn't tease that out of the existing language?
I don't think so at all, Your Honor. Everything in this notice of claim squarely is dealing with the wrongful death claims. It's not dealing with any direct liability claims.
That's the lowest threshold for imagination that I've ever heard expressed in any context. What else would they say? What else could they say except your staff? If they're asserting a negligent supervision claim, what else could they say except we don't think your staff was properly trained?
Just that. That's all it's required.
But that's just a conclusory statement. That doesn't provide any basis. I mean, your staff might have been the best trained in the history of staffs. And you might then reasonably ask, what else could we possibly have done? But now you're saying, even under those facts, that conclusory statement would have been enough.
It would have been enough from my perspective, because the threshold, the court's not wrong, the threshold is extraordinarily low for the facts that need to be asserted in a notice of claim to apprise the county to go off and investigate. But when, in a situation like this, there is absolutely no facts, none, discussing or alleging there was some sort of deficient supervision or training or policy, it's not referenced.
And so then your position is that in the absence of a conclusory statement, the public entity can sit on its hands and contentedly beam at the fact that it will face no liability rather than simply ask a question of its own employees. That's the way the law is written and should be written.
Well, the notice of claim does not dictate what the public entity has to go off and do afterwards. It's merely to put them on notice. And under the narrow scope of that...
I'm confused on why you don't think that's notice. They say he was in your care and control, and he died. And I would think that even a first-year law student would say, well, how did he die and why did he die, and would start to investigate. And that's all the notice of claim is required, right?
Sure, but that sort of investigation wouldn't necessarily touch on what are specific policies for X, Y, and Z, and are those even going to ever be challenged? We don't know. I mean, we don't know. So I'm struggling.
Well, you have to know why he died and what happened and what policy was in place. I mean, it's a jail for crying out loud. They don't do anything without a policy that controls it.
You know, I would put it in the context of the claims that were actually alleged, Your Honors. If you look at their complaint, they alleged later on, this is now their training and supervision claim, that we failed to provide a duty of reasonable care for the hiring, retention, training, and supervision of all individuals who worked at La Paz County Jail. So we're supposed to, when a death occurs, look at all individuals within La Paz County Jail?
Well, let me ask you this. Is there a policy?
Because that's their claim.
Is there a policy in the La Paz County Jail that when somebody dies, somebody writes a report?
Your Honor, I honestly don't know, because I
Really?
haven't gotten that far in this litigation.
And everybody goes to lunch?
I would presume there absolutely would be, Your
Okay.
Honor.
So if somebody writes a report, I would assume that the policy is that they're going to assess the manner of death and the cause of death, right?
Right?
And they're going to look at it to determine whether anybody did anything wrong in connection with that death. They'll do that without a notice of claim, without a plaintiff, without anything. That's just the way the government works, right?
Sure.
Okay. So what else do you need? You were going to do it anyway. What, you need a notice of claim to prompt that?
I think a notice of claim needs to, again, apprise us. This is about assessing liability, assessing exposure. So regardless of whether we would do our own independent investigation or not, how do we assess whether $2 million in this case is the appropriate sum of money that the county would want to get rid of this case at an early stage, pre-litigation, without at least some indication of the facts that will be later asserted against them?
Well, under the system you're positing, you wouldn't, because there's a binary decision here. We settle for $2 million, or we just claim ignorance, and then we don't have to settle for anything because nobody can ever sue us. That's the world you're painting, right? So you're not under any incentive to do any investigation.
Well, Your Honor, I think the purpose of the notice of claim isn't to police or ensure that a municipality is self-policing itself. It's merely to put it on notice about what future claims could be brought against it so it can evaluate whether it wants to settle the case early.
Well, one might argue that the purpose of the notice of claim is to act as a trap for the unwary and preventing people from suing the government after the waiver of sovereign immunity. And it has served that purpose rather well. But the stated purpose is to allow an entity to intelligently evaluate whether to settle. It doesn't require a counteroffer.
Sure.
It doesn't envision any settlement process that actually happens in the real world, right? There's a sum certain, and you can make this binary decision. Do you settle or do you not settle? And if you don't settle, you claim ignorance, and then you just get a dismissal. So there's really not much reason to investigate under the notice of claim statute. There are other reasons to investigate, and I have every confidence that La Paz County probably actually did a fairly thorough investigation here, right?
Absolutely. We haven't gotten to any discovery, so...
Right, so there's a complete disconnect
But I would
between what
absolutely
happened in
assume so.
reality and what you're saying the notice of claim statute requires.
But to use your word, how does a county intelligently review its liability without knowing basic facts as to what would be asserted against it later on?
Well, I'm going to repeat myself, but there's a decedent, and he was in the control and custody of your client.
Sure.
So all of the facts around what happened, you have. You don't need them to say, boy, there's this outside thing. You have the facts. You can investigate.
We may well
Why
have-
did he die?
I'm sorry, I don't mean to interrupt, Your Honor.
No, that's fine.
We may well have all the facts, but how do we know to go look for specific facts that may or may not be relevant to the analysis?
Life is tough when you're the government.
That may well be, but there's been no case that's ever imposed that kind of burden under the notice of claim statute. None. that I'm aware of, researched before coming to this court.
Well, this may be the
And there's
first
certainly
time
been
that
none
this
briefed.
argument has been made, but there have been plenty of cases that have gone to trial after a notice of claim with this level of detail in it. So I mean, you may have been the first one to make this argument that the notice of claim statute should pose an even stronger barrier to claims than it has historically been held to do. But that doesn't mean that this case is a novelly aggressive attempt to collect from a government entity.
And Mr. Ackerman, just to follow up on that, I know, and maybe you just slipped, but the notice of claim statute places no burden on your client. The notice of claim statute places a burden, and you said burden. The notice of claim statute places the burden on the plaintiff to alert you to a potential claim. You don't have to do anything with that notice. There is no burden on you at all. So you are wrong if you say, oh, don't place that burden on us. There is no burden.
No, Your Honor, that's correct. Again, the language of Deer Valley, it directs that all claims shall contain facts sufficient to put the public entity to understand the basis upon which liability is claimed. The notice of claim has to do that.
If somebody called you as a defense lawyer and said, we had someone in our custody who died, would you not have a pretty ready series of questions that you would ask the client?
Sure.
Of course you would. So you need them to tell you what to ask? You would know what to ask in your sleep. If somebody tells you, we had someone in our custody and they died and we're afraid we're going to get sued, you would immediately know what to ask. Who was around them? Were they the appropriate people to be around? Did you have appropriate safeguards for your inmates? All those questions, and I guarantee you that someone within the county asked those very questions in the internal investigation. So where are you prejudiced by the lack of direction from the putative plaintiff?
Because again, how do we properly assess liability if we are not put on notice that is going to be a claim that's going to be brought against us?
You mean you hope that they might miss a claim?
Your Honor, the notice of claim statute is written the way it is. It says
but it
they need to
doesn't-
provide sufficient, I mean,
The
in
notice
other
of claim
words,
statute said it really has no language bearing on the discussion we're having.
well, it
The
says
notice of
facts
claim
sufficient.
statute has inspired judicial decisions like Deer Valley that go well beyond the statutory language. So we can't just rely on the language of the statute and say, done.
Well, then why else use the words facts sufficient? Facts sufficient to permit the public entity on notice of the claims.
I guess that's...
It would read those words out of the statute.
Okay, so what facts would have been sufficient? I believe you said some minutes ago that a conclusory statement
Yes.
about supervision would have been sufficient. That statement that you said would have been sufficient actually contains no facts. It contains a conclusion. It contains a legal assertion that is not a fact. And yet you said with that conclusory statement, we're good to go.
It at least gets us to the much closer call of whether or not there are facts sufficient here. But when you have the absence of no facts, that's why this argument is being presented to this court in this case. There's no facts. So how do no facts reach facts sufficient in the notice of claim?
Well, I think the fact that someone died and he was in custody, those are both facts. In fact, they're
Absolutely.
undisputed facts.
Sure.
Okay. And I think we're out of time, so thank you.
Yep.
Your Honors, only just very briefly on that issue of what's actually in our notice of claim, which was Exhibit A to our response to their motion below, we specifically set forth in there that neither the supervision nor the security checks were adequate, resulting in Mr. Neff having the means and opportunity to commit suicide. That is certainly squarely what I heard Mr. Ackerman is saying we should have said. It was in there, and the question that the county and Sheriff Reeson have to ask when they receive that is, well, is that a result of our policies? Is that the result of negligent failures of individual corrections or detention officers? It's more than sufficient to allow them to assess their liability. And I think, as the court rightly pointed out, what they're asking for here is that at the notice of claim stage, people with claims against government entities actually go beyond the notice pleading standards that Arizona has recognized at the complaint stage. That can't possibly be what the legislature intended. Unless the court has any further questions for me, thank you, and I ask that the court reverse the trial court's ruling.
All right, thank you. Thank you, counsel, for your arguments. The matter is now under advisement. The court will issue a written decision in due course, and we will stand in recess to allow the next case to set up.